Can a person who has consented to and benefited from a contract later declare it illegal? Hi everyone, my name is Yanolo Asholapitaiwo, an associate at Sukanko, and welcome to today's episode of Stay Informed. In this episode, I'll be discussing with you the decision of the Supreme Court in the Pan Ocean case. That is the Pan Ocean Oil Nigeria Limited against KCA Dutag Drilling GmbH and KCA Dutag Nigeria Limited. That case is all about arbitration and enforcement of arbitral award. Arbitration is one of the mechanisms of alternative dispute resolution where there is a neutral party who listens to the evidence of both parties and gives a decision which is known as an award, and the award is binding on both parties. In the Pan Ocean's case, the respondents, which is KCA Dutag Drilling GmbH and KCA Dutag Nigeria Limited, entered into a land drilling contract with the appellant, which is Pan Ocean Corporation. The contract was for the drilling of an oil rig and other associated drilling services, which is to be done by the respondent to the appellant. After the drilling had been done, invoices were sent to the appellant. After several unsuccessful attempts to get the appellant to pay the outstanding fees, the respondent took the matter to arbitration. It is pertinent to know that in an arbitration, the parties must have consented to it. There must have been a clause in the contract which states that if the parties don't see eye to eye on an issue, they can always resort to arbitration. The respondent took the matter to arbitration. While the arbitration was ongoing, they came to a settlement and they requested the tribunal to issue an award by consent of the parties. So the tribunal panel made a consent award based on the settlement agreement between the parties in favor of the respondent for the services provided by the respondent. The appellant voluntarily made a part payment of the arbitral award sum, and a substantial amount of the award sum was still left unpaid. So after several unsuccessful attempts to get the payment from the appellant, the respondent applied to the High Court of Lagos State to enforce the arbitral award. They got the enforcement and made the appellant pay some of the money. After the respondent had recovered some of the award sum through garnishment proceedings, the appellant applied to the court for stay of further execution and an order of the High Court setting aside the order of enforcement on the ground that the contract was illegal. This application was, however, dismissed for lacking merit. Unsatisfied, the appellant appealed to the Court of Appeal, and the Court of Appeal also dismissed this case for lacking merit. Still dissatisfied, the appellant appealed to the Supreme Court. In a unanimous decision, the Supreme Court dismissed the appeal and affirmed the decision of the lower court. Some of the issues that were raised at the Supreme Court was that, can a person who has benefited and consented to a contract declare it illegal? 2. Can a party who has failed to raise a jurisdictional objection during arbitration raise this later? And the third one is that, which court has the jurisdiction to enforce an arbitral award arising from non-payment for the services rendered under a contract for operation of a drilling rig? On the first issue, it was stated that it is dishonorable for a party who has benefited and consented to a contract to later declare the contract illegal. On the second issue, the appellant contended that the contract was illegal because the first respondent, which is KCA Dutag, was a foreign company that was not incorporated in Nigeria, and that by failing to comply with the provisions of Section 78 of the Companies and Allied Matters Act, which states that for a company to carry out operations in Nigeria, it must first be registered in Nigeria. So the fact that they failed to comply with that provision, it makes any operation they do in Nigeria illegal. Just like the contract is illegal between the first respondent and the appellant, it is also illegal between the second respondent and the appellant. And as such, the High Court of Lagos State does not have the jurisdiction to enforce the contract. The respondents, on the other hand, stated that this objection should have been raised during arbitration according to Section 19 of the Lagos State Arbitration Law. The fact that the other party have not raised this issue earlier means that their right to raise the issue in court now has been foreclosed. The Supreme Court agreed with the respondents and stated that they have lost their right to raise this issue, so they do not have the right to raise it now by virtue of the Lagos State Arbitration Law. On the issue of whether the state high court has the jurisdiction to enforce arbitral awards arising from contracts which has to do with the provision and operation of an oil drilling rig, the appellant contended that since this matter has to do with mining oil fields, oil mines, natural gas under section 7 subsection 1 of the Federal Air Court Act and section 251 subsection 1 paragraph N of the Constitution of the Federal Republic of Nigeria, the matter should have been filed at the Federal High Court and not the State High Court because it has to do with natural resources or natural gas. The appellant further submitted that the ruling of the High Court enforcing the arbitral award should be set aside because the High Court does not have jurisdiction. The Supreme Court held that the respondent's claim was for a breach of contract, and this does not fall in the purview of section 7 subsection 1 of the Federal Air Court Act and section 251 subsection 1 paragraph N of the Constitution of the Federal Republic of Nigeria. The Supreme Court further held that the provisions of the contract and the activities that occurred in the contract are two different things. What the respondents are claiming is the breach of the contract and not the activities that are in the contract. Therefore, the claim of the appellant was not considered. The Supreme Court gave judgments in favor of the respondents and held that what was in contention was the breach of contract and not the activities that occurred in the contract. What we are saying in essence is for you to know the position of law as regards these issues. On the first issue that we treated, saying that whether a party who has consented to or benefited from a contract can declare it illegal, the position of law is that once a party has consented to a contract, that party cannot declare it illegal and try to run away from his own responsibility. This was the decision in the case of AG Western State against Fakorede, where the court held that a party cannot step away from his responsibility of fulfilling a contract by saying that the contract is illegal. This will amount to approbating and reprobating, which is not recognized in law. On the second issue, which is raising objection during arbitration, section 19 of the Lagos State Arbitration Law already made that clear to us that you have to raise your jurisdictional objection during arbitration. Once you do not raise the issue during arbitration, you cannot later raise the issue in court during enforcement of the arbitral award. In conclusion, the decision of the Supreme Court in this case restates the position of the Nigerian court when it comes to arbitration. It's just a way of saying that people will not be allowed to frustrate the enforcement of arbitral award through the use of litigation. It's saying that awards gotten from arbitration can be enforced successfully without people bringing irrelevant application to court saying it's illegal. Thank you very much for staying with me. See you next time.